Olua, and I welcome you to yet another live session. Today, we want to talk about a very interesting case. It's a decided case. It was decided in 1976. The Supreme Court gave the decision on Friday, 8th of October, 1976. How many years ago was that? And this is a case that has so many legal juggernauts, both alive and dead, involved, it had people like Chief D. Awolo, Chief O. Awolowo. It had people like Akpedeye. It had people like Chief Fani Kayode, and so on. Chief F.R.A. Williams, Fatai Williams, and so on and so forth. So it's a very important, a very interesting case. It's a land case, a land matter. You know that in Nigeria, property disputes are very rampant, especially in some litigious localities. So today we want to talk about Idundun and Okumagba. We want to look at what the court decided in that case and how it may apply to you regarding your legal relations with land or over land in Nigeria today. Very important. Please share the video with your friends. Don't forget to like the video, and don't forget that you can continue the conversation in the comment section. You're welcome. Thank you to everyone that has joined and everyone that will stream this session. Thank you so much. Let's talk about Idundun and Okumagba. This will not be the first time we're talking about on the channel. There's a short that we did about Idundun and Okumagba. Should be last year or the year before, probably last year. Please watch that short. Just Google Idundun and put it in the search box for YouTube, Idundun and Okumagba. So let's talk about that case today. I've made a few notes as usual, but I want to read out the names of the parties to the case. D.O. Idundun, those are the plaintiffs. They were called plaintiffs then. Now we call them claimants in Nigeria. D.O. Idundun, Chief P.O. Awani, A.E. Hesse, C.A. Lori, J.D. Onoru, for themselves and on behalf of Ogitsi family of Okere, Wari. And then we have Ishekiri Communal Land Trustees and Erejuwa II, the Olu of Wari, as he then was, is late now, for himself and on behalf of the Ishekiri people. So those are the plaintiffs in this case. I just read it out because I wanted to point out the fact that when you're claiming for ancestral land or family land or communal land, as in this case, everyone in the community cannot come. So they need to have some representatives. So those persons must sue for themselves and on behalf of the entire family or the entire community. Very important. And in most cases, when filing, there will be proof filed alongside the originating processes, to show that they have lawful right to actually sue on behalf of the entire family or on behalf of the community, as the case may be. So those are the plaintiffs. You can see here that the Olu of Wari is also part, because it's a land that comes under his jurisdiction. The plaintiffs were also claiming that, he had overlordship of the land, as part of proving their ownership. And then the defendants are Daniel Okumagba for himself and on behalf of Olodi, Oki, and Iobaju families of Idimi Sobo. I hope that's correct. Or Kerewori. Yeah, those are the defendants. So this is a Supreme Court decision, which means that it has gone through the ranks, trial court, court of appeal, because you start land disputes at the High Court. So then it goes to court of appeal, and then it goes to Supreme Court. So the case has gone through. So what really happened? Let's use FIRAC. I put some notes here, and I used FIRAC, to help us understand it easily. What really? Yes, appeal, then Supreme Court. Thank you, Ruki. What I mean is, it starts at the High Court, then goes to Court of Appeal, then it goes to Supreme Court. Yes, that's perfect. So let's look at the facts. That case is a very difficult case to read. I don't read it. I read and read and read and read and read. So the Supreme Court's reportage needs improvement. This is 2024. people should be able to pick up a judgment of the Supreme Court and at a glance or initial reading have a fair idea of what is going on. Of course, I understand it, I'm a lawyer, but reading the through the case, it was very difficult and it was very, very hard was that's the word. Yeah, not hard. It was hard was to read, so very important. So facts. So that's how I have to put it down. You know that when I'm doing decided case, I talk extempore most of the time, but this one I have to put it down so that I will not mix things together. So when we get to the parts where we are talking about what the outcome of the case and how it applies, yeah, we can go extempore. So the facts of the case is that or are that one, the Ogitsi family claimed ownership of land in Okere, Warri, based on Ishekiri customary law and historical claim. Essentially, they were saying that a piece of land in Warri belongs to them because it's been in their family, for a long time. So, and that is ancestral family land, You know that in those days, one of the easiest and perhaps the most pervasive means of land ownership was first settling. That's how people came into or had ancestral land, first settling. So what does it mean? It just means that people were quite itinerant in those days. So if, for instance, you move as a Nigerian and you move to, maybe you move to Georgia in the United States. And at that time, Georgia was not is not yet a populated place. Maybe it's not even Georgia yet. Maybe I moved now, Mujola Lua Livingstones. I moved to that place, and then I just find an expanse of land on here, inhabited and whatnot. And then I just start living there with my family. Then I start to develop it, maybe from one house dead, I build another one, and then I marry, I have children. Then maybe I build a clinic or an hospital, a clinic most likely, and then I open a store. Maybe I build a filling station. These are modern contents of a society. Anyways, what do they have in those days? Perhaps they start a market, in that locality. Then they start farming in that locality. By that, after a period of time, people who are probably traveling by, passing by, or who come to trade in that market and go back, they'll start referring to as Livingstones. I'm going to Livingstone Market. I'm going to Livingstone Settlement. I'm going to Livingstone Village. As such, I've become a village owner. So now I have ancestral land. So now, if anyone wants to come into that territory to live, to settle, they have to come and take permission from me. So I'll give them the right to live, or I might even give them a portion of the land. Maybe I could lease it to them. I could do an outright sale to them, or I could just give them customary ownership, customary tenancy, whereby they pay me tributes, maybe from the produce from farm produce, year in year out. So that is how I will become. So after I pass the land to my family members, maybe to my children, and then it passes to their children's children, it becomes, that land becomes our own. It is ours as such. So when we're telling the story, it is now our ancestral land. We exercise all rights of ownership and possession on the land, and we are the final authority regarding sale of the land, partitioning. I've done a video on partitioning, please watch it, regarding renting out the land, maybe leasing the land to someone, customary tenancy, giving it to people to use maybe for farming or to stay for a while, or for a long time, paying us tributes, in whatever agreed mood. Maybe in working, tributes could be maybe they work on our farm for a period of time, or they give us farm produce or whatever they are selling or making year in, year out, just to renew our ownership rights, to continue to acknowledge that we are the owners. So that is how people owned land in those days. First settlement, and then it starts to pass. You pass it on to your children, onto your children. I was just reflecting on a land dispute that I had mediated a few years ago. What had happened was that, someone had come to complain that they bought land, and then a certain woman was disturbing them, claiming that she's the owner of the land, and that they should get off the land. Now they had bought it from someone else. So I said, instead of fighting this battle on your own, let's invite the person that sold the land to you. So let them tell us if they also sold it to this person that is challenging you, or if the person that this person had bought from, if they know the person in any way. So they invited the person that sold the land. Let's say this complainant was A, and I now said A is contending the land with B is contending the land with A rather. So B is saying that, oh, Mrs. So sold it to me. Now I now told A that bring the person that sold it to you. So the person that sold to A is C. So when he brought C then told me the story of how the land is ancestral land, how his father, had given it, how he had inherited it from his father, who had inherited it from his own grandfather, who had inherited it from his great grandfather, who was the first settler on the land, and had given it. So the land was devolving through their generation. That's the story that I had. Then he now said that the person on the other side, the woman who had sold to B, that woman and her family were customary tenants of his own grandfather on the land. They were not owners, they had no right to sell, and that they would pay his grandfather tributes in palm oil and farm produce every year as customary tenants. That although his grandfather lived in another village, those people lived in that village where the land is, and they brought tributes every year to show that they are customary tenants. So after the demise of his grandfather, who gave the land to his father, and then the land came to him, they were now saying that since everyone had gone to the city and no one was really living in the village to be exercising any rights over the land, let them sell it. So he made an outright sale to Mr. A among several other people. So I said, okay, we're getting somewhere. Let us now invite this woman. We'll name her D, who sold to B. Let's invite her and let's see her side of the story. So when she came with some other members of her family. And then when they told their own story, that's very funny. When they told their own story, it turned out that they and Mr. B, I'm sorry, now A and B are third-party purchasers. So when Mrs. D came with other members of her family, it turned out that they and Mr. C were members of the same family. They were all great-grandchildren of one ancestor who owned land, village A, village 1 and 2. So what had happened was that village 1 was where he lived primarily. Village 2, he had moved from village 2 to village 1. But he now put some of his sons in village 2. So the sons that lived in village 2, their own grandchildren or great-grandchildren was Mrs. C and other family members. Now the son that stayed with the great-grandfather in village 1, his own great-grandchildren was Mr. C. So all of them are direct inheritors of the land, and they had so inherited. So naturally, because they both stayed in different places with the progenitor, they also inherited where they stayed. Now, Mr. C, after having sold what he inherited from their progenitor, now went to that village and started selling what his co-inheritors owned, because they had not sold theirs. So he was now claiming that because they were co-inheritors, but because those people were placed there by his great-grandfather, and they used to come to village 1. They would come maybe once in a year or a few times in a year. They would bring produce from that other side to them. He was now claiming that the produce they brought was the tributes, and that they are customary tenants. But when they came and they told me the story, the real story, he was there, of course. It's face me, I face you. And I said, Mr. C, all these things they are saying, is it true? He could not deny. So he now said that we should look for a way forward. So then we now started to look for a way forward. But I'm just trying to explain how land was inherited and how people came into possession and ownership of ancestral land, historical land, family land, community land, communal land in those days. So that's essential. I hope you get the gist. So in this Idundun and Okumagba's case now, Idundun and all the other people that are plaintiffs what they were claiming is that the Ogitsi family, that they are the owners of the land, that piece of land that was in Okere in Warri, based on Ishekiri customary law and historical claims. And they even brought the Olu of Warri to explain that it was the overlord. So he could also attest to the fact that their family owned the land and they had been in ownership and possession of the land for a long period. Now, in land ownership, in land disputes, how you prove by different means, but the court does not decide based on the weakness of the other party's claim. The court decides on the strength of your case. So if you're claiming that the land belongs to you and you go to court, you must come correct, because if the other party comes, whether their own counterclaim is weak or not, or even if they do not show up at all, the court will rely on the strength of your case to hold for you or hold against you. So even if you have a case where you are contesting ownership of a piece of land and you go to court and the other party does not come and it's just you giving evidence, the court will require of you strong evidence sufficient enough to put all doubts at rest that the land actually belongs to you. So it's not going to be a free pass just because your contenders do not show up, or even if they show up and they have weak evidence. So one thing we must know about land disputes is that it thrives on strong evidence. And we're going to be talking about the type of evidence that you can use. Basically, oral evidence and documentary evidence. Those are the two types of land. And you know that the court has held that, and the Evidence Act has also held that where there are conflicting documentary evidence, oral evidence can be called to sort it. Also, where oral evidence is weak, you can this second part is not in the Evidence Act, where but by practice, after giving oral evidence, it is better if you support it by available documentary evidence, especially if you see that both of you are telling different stories and are insisting. So if you have documentary evidence to support your own, you add it. So let me go back to the facts of the case. We're using FIRAC, remember? So the Olodi, Oki, and Iobadu families, that's the defendants in this case. That's Okumagba. Okumagba is representing these three families. The case is Idundun and Okumagba. So Okumagba countered the claim of the Ogitsi family by saying that they are the owners of the land and that they have exercised long possession and ownership of the land. So they had said that then both parties presented their evidence, and then the court found that the evidence were conflicting. The court found that the parties presented conflicting traditional histories and evidence of acts of ownership. So that's F, facts. I, the issue. The issue now is that who is the rightful owner of this land in question? That's the issue. Now, the rule. The court applied the Shekiri customary law and relevant legal principles to determine ownership, including traditional evidence, acts of ownership, and then of course we'll also talk about the burden of proof. I've explained burden of proof in land and property disputes to say that it is on the plaintiff primarily. You are to prove that you're actually the owner of the land. Very important. The burden of proof in land disputes is on the plaintiff. Very, very important. So he who asserts must prove, essentially. He who asserts must prove. Now, the court analyzed the evidence by both parties, and then the court now used some rules, which now became, the principles that came out of this case. If you watch the shots that we did on Okumagba, you would notice that what we said is that you can prove land ownership by 5 means. And you can prove either of them. You don't have to prove all of them, but you can prove one or more, in proving that you're the owner of the land. You can prove, you can use traditional evidence. That's, you talk about the history of the land, how the land came into your family. Like that case that I spoke about, traditional evidence, they described everything to me, how it happened. I even had to draw a family tree as they were talking so that I would not miss out, how the land came from great-grandfather to grandfather to father to son, and as the case may be. So traditional evidence, that's historical facts. You can prove that. Genealogical connections, which is just what I've talked about, you can prove land by that traditional evidence. The second one is by acts of ownership. So you can prove land ownership by showing the court that over the years you have exercised sufficient, positive, and long-standing acts of ownership, that you've been exercising acts of ownership over it for a long period of time. So that's how to prove land ownership. Another means of proving land ownership is by proving that you are the owner of an adjacent piece of land. So if you have land A and land B now, and you are the owner of land B, you can come to court and use land B to prove that I'm the owner of land B, so I'm also the owner of land A. Especially, let's say you got it at the same time or from the same source, whatnot. So proving ownership of adjacent land is also one of the means of proving, that you are the owner of a piece of land. Also, another means is by proving that you have been in long possession of the land. Proving that you have been in long possession of the land. Remember that possession is 9/10 of the law. Possession is 9/10 of the law. So in most cases, the person that has possession will be presumed to an extent to be the owner of the land, except controverted. If, for instance, you recall in your locality now, maybe mechanic states. Does anyone really know who owns a mechanic state until maybe they pursue them, or they drive them off the land, and then the owner takes it up and maybe sells it or builds something on it? Nobody knows. You just assume that. We all have it at the back of our mind that mechanics, they usually lease or rent their states, their workshops, but nobody really knows. So if a mechanic has been on that piece of land for say 30 years and no one has come to check and said, are you the owner of the land? Or someone has not shown up and said, we are the owners of the land, we'll be paying us rent, or be bringing customary tributes at the end of each year, or they have not come and put something on the land. This land belongs to so and so family. Beware of frauds, or beware of our uncle so and so. If they have not done something like that, after a long period, possession may be presumed as ownership. So long possession is one of the means of proving land. It doesn't mean that each time that someone possesses land for a period of time, they automatically morph into an owner. No, what it means is that if you're trying to say that you are the owner of a land, you can come and prove it by showing that you have been in possession of that land for a long period without any disturbance or any controversy from any source or any adverse contender. So if you have built a church on a piece, maybe you bought a piece of land now, and you bought it and you built a church on it, and the church has been there for, say, look at seminaries. Seminaries have been on pieces of land for, say, 100 years, some of them more than that, and if no one has come and said, oh, we are the owners, if a seminary were to be in dispute with anyone now, one of the means they can show to the court is that we've been on this land for 100 years. Never in our history has anyone come to say we are the owners of the land. This, amidst other things anyways, so if they are using long possession, they can also have documentary evidence, which is the fifth way of proving land ownership, by documentary evidence, and said that, this is, and they can say that this is our title documents where we purchased this land in 1900. We purchased it from Albert Macaulay himself. So documentary evidence is another means by which you can prove. So that's why I said that in proving title to land or ownership, you can prove one or any or more than one of these means. You can prove long possession. You can prove sufficient, positive, uncontroverted acts of ownership. What are acts of ownership? Sale. Maybe it's a larger piece of land. An acre has 5 or 6 plots. Maybe you sold 2 plots. In 10 years, you sold 1 plot. In 2010, in 2015, you sold another 1 plot. No one questioned you. And now they are coming to say that, you are not the owner of the land. So, sufficient acts of ownership that you can use to prove in that instance is that I sold plot 1, no one came. I sold plot 2, no one came. I'm the owner of this land. When I was selling it, and the people I'm even selling it to, possibly as I'm selling it, they built a bank. As they bought it, they built a bank. As they bought it, they built a restaurant. No one came and said, this is our land. How can you build on them? My third-party purchasers have not even been controverted. Talk less me, the owner, that sold it to them. So, that's an act of ownership. Sale. Maybe lease. You have been leasing out the land. Maybe it's a rental property. Maybe a school hostel. and you've been renting it out to students. Everyone knows it's a notorious school hostel. You've been renting it for 30 years, and then someone just wakes up one day and starts saying that you are the owner of they are the owner, the rightful owner of the land upon which you built the hostel, of the hostel itself. So one means of proving is by showing that I've been renting out this hostel for 30 years and no one has ever come to challenge me. So this also highlights that equitable principle, or that principle rather, uh, the maxim of equity, that equity aids the vigilant and not the indolent. So if you say you are the owner of a piece of property, you cannot stand by watching another person exercise acts of ownership for such a long period, doing nothing about it, which is what came up in this case against the plaintiffs. And then you wake up 1 century later and then say that you are the owner of the land. What do you mean? What were you thinking? What were you doing? So that is it. That's so you can prove by long possession. You can prove by documentary evidence, by proving ownership of adjacent land, by traditional evidence, by sufficient, uncontroverted, and positive acts of ownership over the land. So these are the 5 means by which you can prove ownership. So that is the application of this is the principle, or those are the principles that came out of Idundun and Okumagba. So as far as the case was concerned, the parties used traditional evidence and they used acts of ownership. They used those 2 methods to prove. Then one of the parties used documentary evidence, which we'll get to shortly. So as far as traditional evidence was concerned, the court found that the plaintiff's traditional evidence was less convincing, lacking in supporting documentation, and inconsistent with historical facts. So it's your word against the other person when you are using traditional evidence and historical facts. So because history is passed from generation to generation, so if maybe this person has come and said, oh, the land belongs to my father, you will say, you remember the case the live case that I gave to you, that I explained earlier. I said that this man had come and said that the land belonged to his great grandfather and the other party were customary tenants. And then when they came, they explained how the land belongs to their own great grandfather too. It turned out that the great grandfather A, great grandfather B is one and the same person. And so they are both descended from different mothers, of course, but from the same progenitor, and they had equal inheritance rights. But because of how they settled and their physical location, the one that devolved to A was different from the one that devolved to B, and so this person had sold his own and then wanted to jump into the other person's side. So historical evidence, the court will listen to both parties. What is this person saying? How did the land get to you? And this will bring us to recital. I've wanted to do a session on land agreements, land agreements since last week. I hope I'm able to do it this week because I want to use a land agreement that I have actually done. I'm trying to lay my hands on one of the earliest land agreements that I did, to explain land agreements. So if I am able to, and if not, I might just draft, I might draft another one, just to explain property ownership, because recitals are very important. In recital, the recital clause is where you talk about the history of the land, how the land went from A to B to C to D to your client as a lawyer and as a person who is employing the services of a lawyer to draft land agreement for you. You must be able to tell them the full story so that the recital will be very detailed. So when you're reading the recital of a land agreement, which is one of the reasons why sometimes I decline to do land agreements for people, because most people don't even know they don't know much about the land. So if you're saying, lawyer, draft agreement for us, it's not so much about collecting 10%, which most people are reluctant to pay anyways, and then putting my seal on a template. No, I want to do something that will safeguard your interests in the future. And that's what we do with the recital clause. So we need to know, oh, this land was owned by the progenitor of this family settled in this land in 1900. And then he gave it to his son, we gave it to his son, we gave it to his son, we gave it to his daughter. And then the daughter now sold it to Mr. So-and-so. Then in 1950, this land was subject to a court dispute. and then in judgment so and so the court held in favor of this person, who then exercised ownership and then sold it to this person who is now selling to you in 2024. That is what a recital should look like, so that if there's dispute in the future, we're able to trace the history of the land, how it got to ABC and how it came to you. I've done a lot of land disputes, especially as a lawyer, and more especially when I was a full-time mediator. I'm still a mediator anyways, but and I was a full-time government mediator, I did a lot of land disputes. And usually what I do is that when you have come and said that, oh, this land belongs to you, this person is claiming against you, how did the land get to you? Once you say that someone sold it to you, my next line of action is, let's get this person to come and tell us their side of the story. We write a letter to them to come, or give me their phone number. I put a call to them personally, at my own personal cost, because I want to help you get to the root of the matter. So I ask them, explain to us how you sold this land to this person. Is it true? When? For how much? Why? How did the land come to you? What kind of title do you have? And then if someone else sold it to them, we continue to trace and to trace and to trace until we get to someone whose title cannot be controverted and who can give us, the real position regarding that particular piece of land. So this is how to claim or how to prove land ownership. So the court found out that the traditional evidence that the plaintiffs had given was weak, and it was less convincing, and they did not have documents to support it as opposed to the defendants. So that means of proving failed for them. Now, another means of proving that they used that came up in the case is acts of ownership. The court found that regarding acts of ownership, the defendants, that's Okumagba side, their evidence of long-standing possession on the land. Yes, let me not jump the gun. Their long-standing possession of the land, how they had been farming on the land, building on the land, leasing out the land, was more compelling. The story was more compelling than that of, the plaintiffs. At some point, the court even found that for the plaintiffs, there was, when they talked about their own acts of possession on the land, it showed that they had folded their hands and watched. So the court was wondering, if the land really belongs to you, when so and so thing happened, why did you not take legal action? You claim that you leased the land to this person. Why did you not take legal action to recover, to assert ownership, when this and this and this came up? So these are some of the things that came up in Idundun and Okumagba. So the court then decided that for the defendants, they had proven their case against the plaintiff. So this is one typical case of no be person wey first call police, they always win case. So in this case, the defendants won. The court held that they had successfully established their ownership of the land in dispute. So some of the things that we've spoken about, which went against the plaintiff, was weak traditional evidence, it was unconvincing, and there was no supporting documentation. For the defendants, they had supporting documentation in support of their own case. Then the defendants evidenced stronger possession, they showed stronger evidence of possession or acts of possession, long-standing possession, and their use of the land, how they had been farming, building, leasing out the land, over the years. And then the court noted inconsistent behavior, which is what I was talking about the other time, such as leasing the land to other people and failing to take legal action to protect their claimed rights. That's on the case, on the part of the plaintiff. So the court held for Mr. Okumagba on behalf of the Olodi, Oki, and Ihobadu families. So the court held that they had been in possession, they had cultivated all the things they said, that cultivated, built on it, their traditional history, was strong and held for them. So that is what happened in Idundun and Okumagba. That is what happened in Idundun and Okumagba. So what else do I have written, put down here? Yes, so What have we learned from Idundun and Okumagba? Possession is 9/10 of the law, quite all right. But in claiming, if there's a dispute, land dispute, you know how to prove it now. You're proving that, oh, we own the adjacent land. You're bringing documents in support. So if you registered the land, maybe you have a C of O or something, you know that now ancestral land ownership is no longer the tightest means of holding land in Nigeria because of the Land Use Act. The Land Use Act now puts all land uh, in trust of the state, in care of the state, for the people. So aside from people who claim that they have ancestral ownership, if what you have purchased is a land that is covered by a C of O, it is land held in trust by the state for the citizens. So you are able to prove easily with a C of O. That's why sometimes we lawyers advise people to stay away from family land because of this kind of situation now. Because only God knows what is true. The court will do what it can prove by the evidence presented to it. So now the court has said that the Idundus, they are not the owners of the land, and all the evidence is not strong enough. So, but for land covered by CFO, once you present the CFO, it is traceable. So you can go to Ministry of Lands and trace a land that is covered by CFO for you to be certain that whoever is claiming ownership is the actual owner registered in the Ministry of Lands. So very important. But these things also have issues. I've settled a case where a local government and a private person both add registration documents to the same piece of land. The question that we had to ask, I had to write to the Ministry of Lands, to question them, even though they never replied, to question them that, did you register one land for two people? Because now this person said they owned the land for so many years. And then when the local government was carved out of another local government, the local government was now claiming later that that land was allocated to them and it is registered in the Ministry of Lands. Both of them brought registration documents. So now, who is the owner of the land? So land disputes are very interesting and they can take all sorts of turns. That is why it's important for you to safeguard yourself and keep a tight case by proving as many of these instances of proving land, especially if it's family land, communal land, ancestral land. So if it's also a land covered by CFO, you know how to prove it. Documentary evidence is your go-to, is your best bet. But in any case, look through those 5 things, 5 means of proving, and prove all or as many as possible, so that you are not idundun in the court of law. I will see you in my very next video. Don't forget to subscribe to this.